Good afternoon, everyone, and welcome to the Brainy Boomer Lecture Series, Les Boomers Brillants. The Brainy Boomer Lecture Series, initiated in 2007 by the Education Committee of the McGill University Research Center for Studies in Aging, to support its objectives, raise awareness, and educate the community at large. The goal of this series was to suggest and initiate practical steps to improve brain health, to prevent other age-related disorders, as well as to promote healthy lifestyle choices amongst the most populous generation in history. Yay! Thank you for joining us today. And now it is my pleasure to introduce our guest speaker, Stephanie Geller, who is a team lead psychosocial assessments for Liana's Senior Transition Support. Stephanie graduated with a master's degree in social work from the University of Toronto and her bachelor's in social work from McGill University. She is in good standing with the Order of Social Workers of Quebec. She has been working in the field with seniors and their adult children for the last 25 years. Stephanie understands the public curator system and is a valuable source for anything related to psychosocial assessments for the homologation of protection mandates and private tutors. Today, Stephanie will be speaking on the topic of understanding powers of attorney, protection mandates, and homologation process, which is a very important topic that benefits us all at every stage of our life. Understanding, being informed, and prepared ensures that our wishes are respected, our finances and personal care are managed by someone we trust, and that our loved ones are spared unnecessary stress and legal complications during difficult times. Please join me in welcoming Stephanie Geller, who will share her expertise today with us. Thank you, Stephanie.
Thank you. Okay. So what I'm going to do is I'm going to just talk a little bit to tell you what today's lesson or talk is going to be about, and then I'm going to do a screen share so that you can see exactly, you can follow along with everything that I'm talking about. And if you have any questions and if they're pressing, just like, I don't know, find a way to either raise a hand. If not, at the end, there's a question answer period. Okay. So I've been with Liana's senior transition support for quite a few years now. And before that, I was always in the public system. I had worked the CLSCs and I had worked in all different places, non-for-profit and whatnot. So if you have any questions, we'll see if we can help you out, okay? So if you give me a minute, I am going to try to share my screen and we're going to take a look here and see if we can do this for you. And I'm going to need to know from everybody, could you see, it says your screen sharing. I'm sure you guys don't get that. Could you see it says Lianis on top, the psychosocial assessment process for homologation? Great.
Just try to make it bigger.
Bigger. Okay, that's a big question. Okay.
Maybe on the top, in the middle, that little square makes the PowerPoint bigger.
I'm trying to see the layout. Let's try layout. Let's try it. See, it says, well, don't know. Background. Nope, that doesn't help me. Oh dear. I don't know how to make it bigger than this.
You have to go to full screen.
Full screen.
You're showing us the slides.
I am trying to find where it is that you're talking about. There's so much stuff here. Let me see. Slide Copilot slides.
On the bottom of your screen, Stephanie, you have
Yeah.
a slider on the right that says 70%. Right next to that, there's like a little presentation mode. So try clicking that icon to the left of that,
Okay,
to the left of the slider. You have 4 icons, so try clicking the one on the left of the slider.
Okay, let's try this.
This one, yeah, that's your presentation mode.
Oh, I think it worked. I think.
Yeah, it worked.
See it now big?
Thank you,
Perfect.
Diane.
Thanks, guys.
You're welcome.
Okay. So, whoop, Whoops, no. There we go. The psychosocial assessment process for homologations. Homologations is a big word. Nobody can actually say it properly. And the reason for that is because we're only in Quebec that you need to know what a homologation is. But if I had to choose one word that sounds like homologation, I would say to activate. What you're trying to do is you're trying to activate the mandate, which is what we're going to talk about, for a person who needs to have their wishes respected, and that you want to choose somebody who will be their responsible person or a few people. The psychosocial assessment can only be done by a social worker. You need to be registered, you need to be with the Quebec order, and you also need to have taken certain courses. You'll see it after on one of the other slides that shows you that you have been trained in this area. That's why the psychosocial assessment as part of the homologation is very important. You will see on the other screens what else we need as well. I'm going to take this. These are the things we're going to talk about. I get this all the time. The question is, what on earth is the difference between a protection mandate and a POA, which is power of attorney? Nobody knows the difference. We're going to talk about that. And then as of November 2022, and that's why you have to be registered as a social worker to understand this, is that new measures have come into place if you are going to be conducting the psychosocial assessment. We're going to talk about what those measures are. Tutorship, that's another word that we use. So if somebody, I'm jumping ahead of myself, if somebody wrote down their wishes in terms of what they would like to see happen in the event of their incapacity, then they wrote it down in a mandate. If they never wrote it down and they need to just have somebody represent them, then we're looking at tutorship in Quebec. But I will explain that. So the psychosocial assessment process, of course, that's the meat and potatoes of what you really want to know about, okay? So I will be explaining that. And then there will be question and answer period, okay? So a protection mandate on top, what is it? So it's a document which a person expresses their wishes and names one or more people to look after them, their property, and their person in the event of incapacity. What does that mean? To look after their person means to make medical decisions or to make decisions on their personal needs. And on their property, the word they didn't put in is the financial. That's the big piece. So if they have property under their name, or they have finances, or the bank for some reason freezes their assets, this is the property piece that we're talking about. Now, a mandate specifically is known that it's something that you have written out as in case of incapacity. We're going to talk about what a power of attorney is, but what some people have is what's called a power of attorney, and they have a clause in it that says in the event of incapacity. That is fine. That is accepted. What it means is that the form was all put together at the time that you did a power of attorney. You wrote down in the event of your incapacity what would happen, and that section, usually starting around section 2.0, is what we would call a protection mandate or a clause that says in the event of my incapacity. Okay? I'm going to jump forward. So, what's the difference between a power of attorney and a protection mandate? This is the big one. Power of attorney is when you are able to make decisions, and you are only at the time that you are of capable mind. So it says mentally capable. No doctor has said we are now questioning the person's capacity to make their own decisions. Power of attorney is what you write down and what things you want to be followed at the time that you're able, in fact, to make these decisions, and that you're able to have somebody follow it through. And a protection mandate only comes into place, although you write it at the time when you're able to write it out, it only comes into place after homologation, meaning it's gone to court. The judge has decided that, in fact, the protection mandate is what we're going to follow. I get this question all the time. You guys have probably heard this. Well, I have a power of attorney already, so why do I need to worry about a protection mandate? This is the obvious one. Power of attorney is when you are able to make decisions, when you are considered incapable by the eyes of the court, usually by a doctor. That is when a protection mandate will come into place. And it doesn't just come into work. You need to apply through the homologation process in order to get a protection mandate to be registered, and then people can use it. It overtakes the power of attorney. So even though you may have named a few people under the power of attorney, that these are the people responsible for you, the minute that you become incapacitated and your protection mandate takes over, either you've named the same people or you've named different people, children or whatnot, but the protection mandate will supersede a copy of the power of attorney. I hope that makes sense. Okay, so power of attorney is only written when you're mentally capable, and that was something that allows somebody to take care of your financial and administrative affairs. It doesn't help you to make personal care decisions, but a protection mandate will look at both. It will look at the financial and the property piece, and it will also look at decisions about your health. Okay, that's decisions as well. This is why it's so important. Changes to the protection mandate as of November 22. Why did they make changes? Well, a lot of people were falling through the cracks and not knowing exactly what they needed to do. So everybody needed to be super clear. If you decided to name somebody as a mandatory or a substitute, meaning the first person that you chose is not able to act or has decided to resign their position, the substitute mandatory would then step forward. But the question is, what were the changes made in February of 2022? Well, they made things a little bit tighter, and they made it so that the person whose protection mandate is coming into place, they want to make sure that the rules are protected for the vulnerable person. Okay, so that not somebody is going to come out of the woodworks and say, hey, I think I know what's best for person A. You wrote it down when you were able to. We are going to go ahead and look at all of these rules, and we're going to go by the eyes. It's obviously easier this way because you chose the people that you wanted to be responsible for you. These are the changes as of November 2022. The first thing it says is mandatory inventory. So within 60 days of the actual homologation process, which means the courts have already determined that the mandate is going to be clear, you need to do an inventory of the person's property. They either have property or they don't have property. The point is that the mandatory that is named in the protection mandate needs to be able to provide this information if the courts ask for it. Number 2, rendering of accounts. That talks about accountability. Okay, so what they're saying is that mandatories in the protection mandate are now required to render an account of all of the administration that they did for at least 3 years. Okay, so you can't just choose anybody and they go, yeah, fine, I'll be a mandatory. I probably don't need to do anything about it. You're responsible, and the court could ask for this information. Okay. Designation of a recipient. The mandate has to include a clause that names the person to receive this accountability. Okay, if no person is named, the court can designate somebody, and that's where people get a little bit nervous because the public curator, who is a person responsible through the courts, could be involved. Now, it's not that the protection mandate will start to get a public curator involved and all of a sudden things are going to go, crazy because the public curator doesn't know my family member. It's that there are some people in life that do not have a person, and they want to be represented. So that's when the public curator will get involved. Will they ask more questions than a family member in terms of the courts? They may. But they're doing their job. And the job, of course, is to protect the needs of the vulnerable person. So we talked, number 4, replacement mandatory rules. So again, a replacement or a substitute. So if I was named as the mandate for my parent and all of a sudden something happened, let's say I was going through a treatment and I just couldn't take on that role as a mandatory, I would have to resign my position, and I would have the next person in line, if they were named, if they were named, not just anybody, who would come in and be the replacement mandatory. So if a new mandatory will to take over, they're not required to take inventory for the previous mandatory completed for rendering of accounts. This is a bit legal. This is something where the notary who you will ask to submit the forms to the court should be able to explain all this information to you. And the last one, of course, is stricter rules on property management. So the new law, it will reduce the full administration for mandatories requiring certain authorizations from a tutor or a council. We're going to get into tutorship after, for significant acts like selling a building. So you can't just say, hey, this person has $3 million worth of property and we're just going to go sell it. There's steps to take place that you can't just, Avon, go in and do anything. Okay, there's certain rules that need to be met by the eyes of the court. I hope that makes sense so far. So I'm going to talk about tutorship to a person of full age. This one we don't have as much. We hear more about protection mandates, but if in fact a person never wrote down their wishes, for whatever the reason is, they never had a chance to write down as part of their power of attorney or as part of their protection mandate, these are the people that I would like to be responsible for me in the event that I am incapacitated. Then we apply to the courts what's called tutorship. Tutorship is a person of full age. You must be 18 and over. We're not talking about kids. We're talking about 18 legal age, okay? The other thing about this is that, sorry, I needed a drink. You name responsible people for you who are going to be responsible. Again, we're talking about property and finances, and again, we're talking about a person. Sometimes it's one person who takes care of everything. Sometimes it's a few. Where it gets a bit tricky is that you don't want to name two people because you can have a conflict between two. So what they ask for is either a person or an odd amount of people, okay, who would be responsible. They talk about what's called a family council. This is only under tutorship. A family council is a group of people, usually 5 people. If you don't have 5 people, they might ask for 3. They might ask for less. They might even ask, say, have the public curator just get involved, okay? And the reason they're doing this is because there's certain responsibilities. Every year, for example, under this family council, they have to review certain information that goes through. So the number that you really need to look at is $40,000. That's just one of the big numbers that I think of, because if a person has more than $40,000 in a property or something and it needs to be sold, you can't just say, okay, I'm the finance person, boom, we're going to sell it. A lot of this information has to go through the family council, and that's usually a group of people, and they need to make the discussions and be able to prove, I think it's yearly, that this information had gone through the family council and was discussed and that it was considered necessary. So all of this tutorship, if someone says, I have no idea what tutorship is, usually at the point where you would be approaching a notary, because a notary is the person who's going to submit the final and original papers back to the court, where you're going to wait for a judgment on a protection mandate. It's usually the notary who's supposed to explain to you exactly how you're supposed to form a tutorship council, okay? So the tutorship of a person of full age is a legal measure aimed at ensuring the protection of a person, the administration of their patrimony, and the exercise of their rights. It's established by the court in the event of the person's incapacity when they require representation in the exercise of their rights. So literally what it's saying is, look, the person did not actually form a protection mandate when they were able to, for whatever the reason was, they didn't, and now we have to put people that will be responsible for this person of full age and will be able to make decisions on their behalf, because they're not able to make the decisions. They are considered, in the eyes of the court, by a medical doctor, mentally incapable of making these decisions. The majority of the files that we see are dementia related, of course. That's mental capacity issues. Under tutorship. There are some cases that we get of people who are maybe just turning 18 and they need representation for things they had a major okay, firstly, let's do this. There's cerebral palsy. I've had a few of those cases. There's a major car accident which has caused brain damage, and therefore now they need representation. We have seen younger people as well for tutorship. And again, you wouldn't do a protection mandate for such a young person, so we are going to apply for tutorship in that matter. Okay. So how does it work? Well, the courts require two things that need to be seen in order to make a judgment to decide that a protection mandate could in fact be homologated. One, I'm going to show you the copy of a medical assessment. So a doctor in Quebec needs to deem the person incapable of making their decisions. And the second one is a psychosocial assessment, and that's the piece that we do as social workers. And it's quite lengthy. Let me show you what it looks like, okay? The first one is a medical assessment. This is a specific form that talks about to homologate a protection mandate or apply for a tutorship. This form is the only form in Quebec that can be used in order to apply to the courts. You cannot have a doctor write on a pad of paper, person can't make their decisions, and then boom, you hand it in. It's not accepted in the courts. The only one that is accepted, and you can even Google this, you put in public curator's office, medical assessment, Quebec, and you're going to find this form. I'm only showing you the form just to show you what it looks like. I've had lots of people who have called in and said, look, yeah, but the doctor says, no, it's not good enough. No, but the doctor did a mini mental test. That's great. We'll take a look at it. But this is the form that needs to be accepted by the courts. This is the only one that they're going to look at. And when we talk about medical assessment, the reason is because it is about 8 pages. On the end of page 7, on the top section, there are two very important questions. And the questions are, this is what the doctor's filling out. Is the person capable of making financial decisions? Yes or no? Is the person able to make decisions about their personal care? Yes or no? That will determine, after all the things that the doctor wrote, if in fact he is saying, no, the person cannot make decisions. Yes, the person still can make decisions. That's why this form is the only one that's accepted. Okay, so this is the paper that needs to be handed in. All originals are the only ones, of course, that need to be sent over to the courts. Okay, but this is the only one. The psychosocial, I just switched the page here. This is the one we use, okay? Psychosocial assessment for homologation and protection mandate. The reason we're talking about this is because this is a much longer form. It's about 16 pages, and they will ask the social worker to really delve into a lot of questions about the person. Now, often I get the question of, yeah, but my family member can't answer these questions, and therefore you're wasting your time. So this is why we will ask the person who is being questioned here certain questions, even if they can't answer them, because we want to hear their answers. And then privately, not in front of the client, we are going to pull a family member aside and we are going to ask them other questions. Because as the page goes on, it will say things like, where were you born? What year did you get married? What type of work were you involved in? And whatnot. Most people can't answer these questions. I'm not even sure I can fully answer these questions. But usually when I get on this page, which is page 1, when I get to the middle part where it says your parents, give me the first name and the last name of your parents, most of the time they cannot recall the first. Maybe they'll remember just the last name, not a first name. Whatever it is, this is the form that's 13 pages. Again, 13 for us to fill out, 16 that goes to the courts. And very specific, all original forms are going to go back to the notary, and the notary in the fact is for a fact is the one who's going to submit it to the court. Everyone says, but how long does it actually take to get there? That's the issue. The forms could be submitted within a few months or so, but it often will wait in the court system until it gets a judgment. So this could happen where sometimes the courts could wait 6, 8, 9 months before they actually see them for the judgment. And unfortunately, that is part of the reason that it takes so long to get this going. Okay. Who do we interview as part of this process, and what information is the courts looking for? Okay, so this is part of the reason that you would probably contact us and go maybe privately. We'll move a lot faster, perhaps, than someone in the public system. Not that there's many people in the public system anymore, and I'm talking CLSCs, in fact, that will fill out these forms. But who do we interview? So obviously, the first thing we're doing is we're interviewing the person who they're concerned about their mental capabilities, right? Mom, dad, a neighbor, whatever it is, we're going to interview them, but we're going to do it alone. We want to make sure that their answers are not given under duress. The other people that we're going to interview are definitely people that were named as mandatories or substitute mandatories in the actual protection mandate. I want to hear, do you still take responsibility, and will you take responsibility and act as a professional mandatory to this person? Yes or no? I have lots of questions. But on top of seeing family members, I want to ask a non-family member as well. Why? Because I don't want the courts to turn around for any reason and go, maybe there's a conspiracy happening here. Maybe all the family they all wanted to get mom out of the way and we wanted to get involved. So what I do when I talk about people that I interview is that I make sure that there is a non-family member. Usually it's a worker who came in either from the CLSC or, now it's called CUSES. If not, if the person's still in a hospital, I might go to the nursing station and ask them a few questions, but I want to make sure that it's documented that I've asked non-family members as well. And what information is the courts looking for? They want to get an evolution of exactly what happened. This is part of the story that we're telling, okay? The courts are looking to find out, how was the person functioning well on their own? What did it look like? What were they doing? When did we start to see that things were starting to not make complete sense to this person? So often I will ask a family member, was there a moment in time? Was there a birthday? Was there a gathering? Was there something where you kind of turned around and said, uh-oh, mom is not fully understanding what I'm saying, or she's not following the conversation, or she's repeating a lot more and she didn't do that before, and whatnot. All of this information is going to be written down because the courts are looking for the evolution. How did it start when the person was fine? When did you start noticing that things were not so well? And what kind of services are they responsible for now? So either it's, I might go into very specifics. Person could eat a hamburger by themselves if they have the assistance of a person, meaning like they're at a retirement home and they need somebody to help them cut up their food, but cannot squeeze the ketchup on their own. I mean, I go into very specific. I want to talk about dexterity. I want to talk about everything that a person is able to do, because I want to keep those things going as long as I can. But I also want to talk about the things that they need further assistance for. Okay. Look at this, I'm almost at the end. Questions and answers. I want to ask you guys, because often you guys have very good questions, and I want to make sure that I am able to answer these questions because, files are very specific. What I want to also tell you before I just take away this page and just leave it at questions and answers is that Quebec.ca is a really good website. It is a paper where they'll actually break down for you, what is a protection mandate? Who could be a mandatory? What are the responsibilities of a mandatory? When do you apply tutorship and whatnot? So I want you guys, if you have a chance, to take a look at that. Often you can go into like LegalZoom and stuff like that. They'll do the breakdown for you as well. But I mean, if you want to just start to kind of get this information together for yourselves now, I would suggest Quebec.ca is a very good website to start to do, okay, to take a look at.